Hello, everyone. Thank you so much for joining us for this year's legislative update. We're going to take just a couple seconds here to kind of let everyone jump on in. So thank you, everyone who's joining us right now. I'm just going to watch as those numbers keep going up on the participants. We had 97 people registered for this webinar today. So that's an amazing turnout. So I know everyone has a lot of questions on the new legislation. So we're excited that everyone could be here today. All right, well, we're about halfway to how many people had registered, so we'll just give it a couple more seconds. But all right, well, I think while the rest of everybody is getting on into the room, we'll go ahead and just start it off and say thank you again so much for everyone for being here today. I know that this is an update I always look forward to, considering all the laws that pass every year. And this year, we have our 2020 laws that were passed, and we're joined again by our WG Law, David Snow and Diana Varat. They were here with us last year, so thank you very much for joining us here again. Some of you might have been on the California legislative update at the state level, which was a couple weeks ago. And although we didn't know at the same time that we were going to have this, we have tried to make ours a little bit different and kind of give it more of the law, legislative, legal defense side that I know a lot of us are concerned about. But it was nice to also have the policy side from APA at the state level. So I thought it would be great to do some introductions and then also tell you about the question and answer. So if you have a question, we're going to ask that you put it in the question and answer box. And for this webinar, we do have the feature on where you can vote if there's a question in there that you would like to ask to. And then if there's more votes for that question, then it gets moved higher up on the question and answer list. But we will be trying to get to as many questions as possible today. So with that, I'd like to go ahead and start by introducing David Snow. So David Snow has been an attorney for just over 18 years now, and David is well versed with very complicated entitlement projects, and that benefits him a lot in the fact that he used to be a planner for 10 years prior to being an attorney. So it's always nice to get David's perspective as a practicing professional planner in his previous life. So thank you so much, David, for joining us for that. And he's well versed in CEQA and land use law. We also have Diana Varat. Diana Varat has been practicing law for quite a long time as well. And she too was an urban planner prior to being, or had education in planning, I apologize, prior to becoming an attorney. So thank you so much for that. And Diana focuses on all housing related stuff and has since the 2017 housing package bill passed. And with all the housing bills that have passed, that takes up pretty much all her time, I'm assuming at this point, to keep up with all of those changes. So with that, I'd like to go ahead and throw it over to Diana to kick us off. Thank you so much.
Thank you, Amber. It's so nice to be here with all of you, though, of course, I wish we were all together in person, but for the second year in a row, we're now doing this virtually, and it's nice to be able to have that capability to share with you all the newest, latest, and greatest in terms of laws that have been passed in the year prior. So we're going to be talking about 2020 laws today, and we will be going through, just to give you a sense of the agenda for today, I'm going to kick it off with a number of housing bills, and then Dave's going to sort of wrap us up in housing and turn to Sequa and some issues with respect to endangered species and wireless cell towers at the end. And then we'll come back to talk about sort of what's pending and what we as planners need to be thinking about as we consider what bills are pending. So as Amber said, this is going to be a little bit different from the APA webinar that was done a couple weeks ago, but there will be some crossover, especially at the beginning, where I will be talking about some of the details of the laws. I'll try to add my perspective, though, as an attorney in terms of, the things that we as practicing planners for public agencies especially need to be really mindful of. So I'll kick it off now with um, some other information that is really useful. The state legislation in the last few years with respect to housing related land use laws has given the California Department of Housing and Community Development some significant responsibilities and obligations and more enforcement authority. I think we all sort of know that from the 2017 and 2018, 2019 updates. And the changes in laws in those years, they have been, beefing up their staff and trying as quickly as possible to get guidance documents out for public agencies. So I just want to make sure everyone is aware of these documents as they're thinking about housing related land use laws. With respect to ADUs, they've put out a couple of handbooks now. The most recent one was from December 2020. It does clarify some of the provisions in Government Code Section 65852.2, which is the ADU law, at least from their perspective and interpretation. And I should say that sometimes you might have a different interpretation. That particular provision of state law has a lot of provisions that are not entirely clear. So there are still some things outstanding that I would say have not been addressed. So that's the first guidance document. The second one is with respect to your housing element updates that we in the SCAG region are all undergoing at this point. State law now requires that we use documents put forward by HCD. So there is the sort of inventory form that they have. They also have prepared a completeness checklist, which is quite helpful for making sure that you're complying with all the requirements in Government Code 65583 and the subsequent sections. And as well, they have a couple of memos on their website, guidance memos, that refer to site inventory requirements, as well as the most recent updates to the affirmatively furthering fair housing requirements, which I'll briefly touch on a bit later. And then lastly, and most recently, HCD put out two separate documents updating their guidelines for the ministerial streamlined approval process under Senate Bill 35. And I'm going to be talking about some of the changes to SB 35 today. And then separately, there's also a document on the Surplus Land Act requirements. So as you may recall, this bill has been amended, or this provision of law has been amended in the last couple of years with respect to when a public agency owns property that it considers surplus and the procedures that it needs to go through before it disposes of or conveys such surplus property. So just know, if you're not aware, all these documents are on HCD's website. It's always a good place to start in terms of a review. If you have questions, definitely check in with your agency counsel. Because there still will be areas that are not entirely clear based on these guidance documents, or that you may think, I'm not sure I agree with this interpretation. Let me talk to my counsel about whether we are following HCD's guidance or determining that their guidance does not align with state law. So that's the first thing to be aware of. So I'm going to dive into the bills now with respect to housing related land use and start with density bonus law. So last year, AB 2345 amended the California density bonus law. So I'm going to start with a brief overview. Many of you are quite familiar with this, but the requirements have changed pretty much every year for the last 15 to 20 years. So it's always good to get a refresher. Under California density bonus law, a project can qualify for a number of benefits if they reserve a certain percentage of the units in that development for specific levels of affordable housing, or otherwise qualify under the sort of specific categories identified, which I'll go to the eligible categories in a moment. What they get when they do qualify for a density bonus are a handful of things that are distinct, and it's really important to keep these things separate. The first thing they're entitled to receive is a specific density bonus. So above and beyond what the otherwise allowable maximum density would be under the city's or county's general plan and zoning requirements. So that's the first thing. And they don't have to take it. They can either take the density bonus or go with the base density. The second thing they get is a specific number of incentives and concessions. And that specific number is based on the affordability level of the housing that they reserve as affordable. And that has been changed. So I'll speak to both of those things in a moment when I talk about the actual changes under AB 2345. If you're not familiar with incentives concessions, what they really are is a request to deviate from otherwise applicable development standards. Similarly, but separately, is the authority for an applicant to request a waiver of development standards or a reduction of development standards where they demonstrate that those development standards, if applied to the project, would physically preclude the construction of the development. There's no specific number or limit on the number of waivers that an applicant can request, but they need to show that the development standards would physically preclude the construction of the proposed development. And then finally, and what another area that has been amended is the ability of an applicant to request a parking requirement that is generally lower than the otherwise applicable minimum parking requirements. So these are the four things that an applicant gets if they are a qualifying project under density bonus law. And the question is, how do they become a qualifying project? Well, there are a number of categories of qualifying projects or eligible projects, as I refer to them. The first is that if you reserve at least 10% of the units for lower income households, or 20% if you're talking about a student housing development, or 5% for very low income households, 10% for moderate income in a common interest development, 10% for transitional foster youth, disabled veterans, or homeless persons, or if they qualify as a senior citizen housing development or a fully affordable development. These are the categories of qualifying projects. The most recent addition has been the 100% affordable. And what that really means is that the applicant has to reserve at least 80% of the units for lower income households. They can reserve that 80% and the next 20% or up to the next 20% for moderate income households, or they can do the whole thing lower income if they want to and still qualify. And those projects, of course, get a number of very beneficial density bonus increases and incentive and concessions above and beyond what those other projects might. So that's sort of the overview of what is density bonus law, how do you qualify? What happened last year is that the state decided that the cap that was previously in place under the sliding scale, essentially if you reserve 10% for lower income, you got a certain percentage, I think it was 20 or 25% max, or rather density bonus above the otherwise allowable maximum density. And that was a sliding scale up to a 35% density bonus. They have increased that sliding scale so that now you can get up to 50% density bonus above base density for all of the sort of traditional project eligible projects. And you always need to look at state law to figure out how much of a percentage they get above the base density and how to calculate that. It's much more detailed and complicated than I think people realize because of the way you calculate the number of units they have to reserve as affordable based on the base density, and you calculate the number of units they get for the density bonus slightly differently. So just be aware that those calculations can be complicated, and you may want to just check in with your agency counsel to make sure you're doing that correctly. The next thing that was changed under AB 2345 is the number of incentives that lower income projects can get, or rather, I should say, it lowered the amount of the project that you have to reserve for lower income households in order to qualify for 2 and 3 incentives. So under density bonus law now, in order to qualify for the 2 and 3 incentives, the applicant only needs to reserve 17% and 24% to receive 2 or 3 incentives, respectively, as lower income households. And the idea there was to increase opportunities and incentives for lower income, specifically projects that include lower income. So those are the first two changes under AB 2345. Another really important change that was made last year that I'm actually seeing applicants use quite a bit now is the change to the parking requirements. So previously for the 2 and 3 bedroom units in a density bonus project, the parking requirement would have been 2 on-site spaces. Now that is reduced to 1.5. So an applicant can come in under this section, which is section P of density bonus law, and request that their parking requirement is reduced based on the number of studios, 1 bedrooms, 2 and 3 bedrooms, or 4+ bedrooms. I should note one thing that kind of trips people up on this density bonus law parking requirement is that these ratios do include guest parking spaces. So if you have a base requirement for parking spaces and then an additional guest parking space requirement, you just need to be mindful that ultimately the applicant does have the authority to request a parking requirement that's sort of inclusive of both and relies on these particular numbers here. So before I move on to ADUs, I just want to mention I'll be coming back to some of the proposed changes to density bonus law, but I think we really are seeing a lot more applicants using density bonus law. So as planners, if you're not familiar with this and you are doing sort of the project approval side of things, I think it's very important to start becoming familiar with the nitty-gritty of density bonus law to make sure that you're aware of what the applicant could request, and what they may be requesting, and what the city's authority is to deny such a request or when they have to absolutely approve the request. Another thing I should mention that was not changed this past year, but was changed the year before, are some of the procedures related to density bonus law. So the agency has to explicitly inform the applicant during the sort of completeness process about what density bonus they're entitled to, sort of what percentage they're entitled to, and what number of incentives and concessions they're entitled to. So when you deem a project complete and they're requesting a density bonus and they're demonstrating that they're reserving, let's say 10% for lower income, the city needs to, at that point, tell them, you are entitled to this percentage density bonus and this number of incentives concessions. They also need to inform the applicant whether they've submitted adequate information for the agency decision makers ultimately to make a decision about the requested incentives concessions and waivers if requested. So just be aware of those procedural requirements that are sort of in the beginning of density bonus law. All right, I'm going to move on to ADUs now. There wasn't a ton that was changed last year with respect to ADUs, but I do want to highlight a couple of things, and then at the end I'll highlight a few bills that are pending. So as many of you know, ADU law has been changed in the last few years pretty drastically, and now we sort of see this as a two-pronged approval process that must be created by local agencies. There are a few categories that the state refers to as state exempt ADUs. We've sort of historically in the last couple of years called them the building permit only ADUs because they are mandated to be approved through a building permit without any planning and zoning entitlement process attached to it. And those ADUs have to be subject only to the specific state standards that are set out in subdivision E of the state law. Separately from those, and if an application does not fall into one of those 4 categories, there is still a process under a local ordinance, or if the city doesn't have a local ordinance, under subdivision A of the ADU law, and sort of the default, the minimal default standards in state law, I should say, whereby an applicant can try to get an ADU that way. It's still a ministerial process, but it might allow for a little bit more leeway than the categories of the building permit only ADUs. So I'm just going to go through a couple of the changes which primarily related to building permit only ADUs, those state exempt ADUs. So under those, oops, sorry, losing my light here. Under the building permit only ADUs, there are 4 categories that must be approved without imposing any planning and zoning standards at the local level. 2 of those categories are for properties with single family structures, and 2 of those are for properties with existing multifamily structures. So for the lots where you have a single family home, it's clear now that a public agency must approve 1 ADU and 1 JADU on a property. Separately, they are required to approve 1 detached ADU plus JADU. So really what the ADU law is saying at this point is that a single family home property gets the single family home, a JADU, which can be up to 500 square feet and included within the bounds of the single family home, and either an ADU attached to the single family home or this detached ADU that is new construction and no larger than 800 square feet. Similarly, that detached ADU could be in an accessory structure and converted into an ADU. So the idea here was really just a clarification that the state's intent was to allow for these 3 units on a single family home property. Separately, for existing multifamily structures, which I should say HCD considers anything a duplex or greater to be a multifamily structure, that property can get 2 detached ADUs on it if it's got an existing multifamily structure, and those would be newly constructed detached ADUs. And alternatively, they could convert non-livable spaces on the property, for example, basements, storage rooms, or garages, into an ADU. If it's a larger multifamily structure, they get more than 1, they get actually up to the number of units that is equal to 25% of the existing units in the building. So those are sort of the 4 categories that are going to go through this very minimal process of just checking off the boxes of whether they comply with the subdivision E standards under state law and the minimal state law requirements. Just to go a little bit more in depth on that 1 ADU and 1 JADU per lot, under that first category of state exempt ADUs, we're mostly talking about converting space, either existing space in a single family development, existing space in an accessory structure, into an ADU. And remember, a JADU always has to be attached, so it's going to be within the existing space of a single family dwelling. And you get both of those. That's the thing. You could convert, let's say, a bedroom in your home and your garage into a JADU and ADU respectively, and that is allowed under these provisions now more clearly than it was before. That provision also talks about when you're proposing those things within a proposed single family dwelling, so arguably building all 3 at once. So just be aware of these provisions. I think most ADU applications and JADU applications that cities are going to see are going to fall within these building permit only categories. The other clarification I wanted to mention with respect to ADUs before I move on to SB 35 is that they have now clarified that because an agency only has 60 days to review and approve these applications, there was already some language stating that if it's not approved or denied within that 60 days, that it would be deemed approved, and that is now more explicit in the state law. So we really need to be careful with our timelines when we get an application in. I should say that 60 days after an application is complete. There's not really a process for deemed complete or making a Permit Streamlining Act determination about completeness because these projects are supposed to be ministerial. But from a practical perspective, I always encourage my staff to respond as soon as they get a submittal in to identify whether that application is complete or not and when that 60 days starts running so that you reduce any conflicts about whether that 60 days has run and the application is all of a sudden deemed complete. So just be mindful of the timelines there and try to move quickly on these applications. Okay, I'm going to move now to SB 35. As a reminder, the SB 35 process was created in 2017 to create a more streamlined ministerial approval process for multifamily residential developments specifically. And this is a process that essentially bypasses the local discretionary process and says if you have a CUP requirement, that's no longer able to be used for this type of project if it fits into the requirements of the SB 35 statutory language. And it substantially, therefore, limits the city's ability to impose local requirements, subjective requirements, and parking requirements through through the local requirements on those SB 35 eligible projects. Because these projects ultimately are ministerial, they are therefore exempt from CEQA. And one of the challenges that the legislators realized that in the SB 35 legislation originally sort of had been overlooked was the fact that if you are exempt from CEQA, you no longer have to go through any tribal consultation process if the application is not seeking a general plan amendment. So what was sort of brewing for a while was building into the SB 35 process some accommodation to deal with the fact that these projects may well result in impacts on tribal resources and how to make sure that they don't do that without the tribes being involved in that process. So I'm going to go through some of the clarifications and the tribal consultation process that now exists for SB 35 projects. And just as a reminder, one of the clarifications was that we're talking about multifamily projects with at least 2 units. The language was not entirely clear before. It is now very clear that it also applies to mixed use projects where at least 2/3 of the proposed development square footage is reserved for residential uses. So this means that both the residential and commercial portion of the project goes through a ministerial process regardless of whether there's a CUP process in place. Those CUPs can still be required for specific uses like a restaurant with alcohol usage or something like that. But for the mixed use development itself, there's going to be no more CUP for that. The project still has to be consistent with the local objective zoning standards and design review standards. And those standards have to be in place before the application is submitted. This brings me to a point that I have been sort of harping on for a few years now and will probably say a couple times today. The most important thing I think we as practicing planners can do to maintain local control is to review our objective zoning standards and design review standards, as well as our subjective zoning and design review standards, and say, is there a way that we can make these standards more objective and less subjective? Because we have seen over and over in the bills coming down the pike the last few years that the state consistently has allowed us to continue to apply our objective standards. The problem is most agencies did not have robust objective standards in place before these laws were put into place because they relied on discretionary processes. So, and I think some agencies have been proactive about this, but obviously it takes a lot of effort, a lot of time, and some money to do this. But if you can put it on your work list to, especially with respect to mixed use and multifamily developments, review your objective zoning and design review standards and make sure they are going to result in projects that the community wants to see. That is the best way to address, I think, some of the ways in which the state is taking away the local control through either the Housing Accountability Act limitations or this type of SB 35 process that's superimposed onto the local planning framework. So I'll get off my high horse for the moment and come back to sort of the changes in law from last year. So this tribal consultation process in SB 35 actually relies on the preliminary application process for housing development projects that was put into place last year under SB 330. That is in Government Code 65941.1. And it essentially has a list of 17 statutorily required pieces of information. Once the applicant submits a preliminary application with all of those 17 pieces of information in it, that under the SB 330 provision reserves their right to proceed with that project under the standards that were in place at the time the preliminary application was submitted. What it now does for tribal consultation purposes is serve as a notice of intent. So when an applicant who wants to pursue the streamlined SB 35 process submits a preliminary application, that begins the process of the public agency having to notify tribes that this is coming and that they need to undergo a consultation process if they want to do anything about mitigating any potential impacts that project might have on tribal cultural resources. So there's a back and forth then between the local agency and the tribe about that consultation. And ultimately, the tribe has a lot of authority here because either the local agency works with the tribe and enters into an agreement that provides for methods to mitigate potential impacts to tribal resources, or if they cannot agree, then that might stop the project from proceeding through the SB 35 process altogether and mean that the project has to go through the normal discretionary review process or whatever the otherwise applicable of review process would be under the city or county's general plan and zoning framework. So there's this back and forth that has to happen once the city receives a preliminary application if it's connected to an SB 35 proposal. And the local agency ultimately can only accept the full SB 35 application, not the preliminary application, but the full SB 35 application if no tribe responded to the notice regarding potential consultation, or the tribe and the local agency agree that the project will not have any potential impacts on the project, or they enter into that agreement regarding mitigation methods and measures. Otherwise, again, the project would not be able to take advantage of the SB 35 process and would have to go through the normal avenues. Just two other pieces of information that SB 35 clarified with respect to the process. If you have a project that's already been approved under SB 35, that applicant can come in and request modifications if they're doing so before the final building permit has been issued. And the local agency does not have a lot of time to review that request, so they have to approve that request for modification within 60 days, assuming the project's consistent with the pre-existing objective planning standards that were in place at the time the original project was approved. There's some limited opportunities for the agency to apply newly adopted objective planning standards. So if the applicant adjusts the unit number or the square footage of the project above a certain percentage, or if the project would have a specific adverse impact because it's adjusting that unit number or square footage, then they might be able to deny a modification. And lastly, cities always have the authority under this to impose new objective building standards. So building standards, at least the objective ones, are not affected by this. And then the last thing is that if there are subsequent permits that are needed related to a public infrastructure requirement that's imposed on this type of project, and that infrastructure requirement has to be done on public land, there are some limitations about what the city can impose on those subsequent permits. So all of this would only come into play if you already have an SB 35 project approved. I think most agencies do not have that yet, but just know that there are procedural things in the state law when it comes to these projects that are pretty stringent, so be aware of that. One thing I wanted to note about a bill that actually Dave's going to talk about a little bit more is AB 1561. So this bill is very specific to the tribal consultation process that occurs related to a project that is undergoing CEQA analysis. So normally the tribes have 30 days to respond to the agency's notification that they've put together a mitigated negative declaration or EIR under CEQA, and that the tribe, if they want to, can consult with the agency to deal with any potential impacts on tribal cultural resources. For this very specific window, because of COVID, just be aware that if you're talking about a housing development project that was determined complete essentially after the emergency declaration last March and up until the end of this year, that notice of consultation has to give the tribe 60 days to respond, not just 30. So just be aware of that slight sort of interim 60-day requirement if you are required to do tribal consultation under CEQA. That's now 60 days, not 30 days. And some quick tips on housing elements, because I know we are all in the middle of this at this point. There were some changes to site inventory requirements under AB 725. Because of the way they're structured, they're not applicable to the Southern California agencies in this housing element update cycle. But just know that for the next round under AB 725, there will most likely be different requirements for sites that will be adequate for your moderate and above moderate categories. For the site inventory, from my perspective, I think the best thing you can do is review the site inventory guidebook from HCD at this point, and just be mindful of how what you do with your site inventory affects future actions by the city under the no net loss provision. So as you may recall from a few years ago, cities, once they have identified sites as available for housing, then are limited in what they can do with those sites. Either because if they downzone, they have to make sure they're upzoning elsewhere to make up for any lost capacity, or if they approve a project on that site that actually has less units than the housing element site inventory said could be built on that property, they have to find other sites for that potential loss in capacity. And that's why we generally, and most attorneys will recommend, when you're putting your site inventory together now as part of the housing element update, consider what level of buffer you want in there, so that every time you want to downzone a property potentially, or approve a project that maybe doesn't have as many low income units as you said might be available on that site, you don't have to scramble in 6 months or immediately to update something else, because you can rely on the fact that there are still available sites within your site inventory. So that's what we mean when we say a buffer. So I would say just work with your housing element consultant and your attorneys closely to make sure that you're thinking about how no net loss plays into that site inventory. There were a few other changes in the last couple of years that might affect what you do in your housing element. Be mindful of SB 330 limitations. I know a lot of cities have things in their existing planning and zoning frameworks that might be considered a cap on the number of units that can be built in a certain period of time or in a certain area. Just be mindful you want to work with your council to make sure that doesn't run afoul of the SB 330 limitations in Government Code 66300. And then, of course, if you are relying on a program to upzone because you don't have enough capacity for your RENA numbers based on your existing planning and zoning framework, be mindful of what those requirements for upzoning mean. Because in some instances, it will require the city to put a program in place that essentially requires a by right development process. So no more CEQA and no more discretionary project approvals for those projects. And those projects will have to contain 20% lower income and have a couple of other limitations on them based on a specific section of the government code. So just be mindful, and again, work with your agency council about what those upzoning requirements may be. And make sure your decision makers understand that by approving the housing element with that type of program in it, there may be arguments made by applicants once that's in place that even if the zoning has not yet been changed, they have to abide by that housing element program. And that's because of a specific provision in the Housing Accountability Act that talks about inconsistencies between the general plan and the zoning code, and specifically tries to address this situation. So just be mindful of that and the way it interacts with project approvals later. Then finally, there have been changes to state law with respect to affirmatively furthering fair housing. There are general requirements under Government Code 8899.50 that say that cities have to take meaningful actions just generally to make sure that we're addressing any past segregation or historical patterns of segregation, and ensure that we are affirmatively furthering fair housing. And there are specific requirements in housing element law that require that the site inventory identify sites throughout the community so that we're not creating just one area of the city where lower income and very low income housing is available. And then there is an assessment requirement that's relatively new, whereby the city needs to basically engage its or assess its history and assess its segregation and its patterns of segregation and housing discrimination in the city. Consider what programs and goals and priorities the city wants to put in place to address that historical segregation and those historical patterns. And then think about how it's going to implement it. And like all programs in the housing element, that has to be on a specific timeline. So I think the affirmatively furthering fair housing provisions of the housing element are going to be looked at quite closely by HCD, and that's why their guidebook on or their HCD memo on affirmatively furthering fair housing is quite useful, because you can see what they're going to be looking for in their review. And I would pay close attention to that because the statute is relatively vague and broad. So in order to get your housing element certified more quickly, make sure that you're following sort of what they're expecting in that assessment and in those programs. So that's it for me for a moment, and I will hand it over to Dave.
Thank you, Diana. And so continuing on the theme of housing and COVID, I'm going to talk about AB 1561 first. Diana touched on some of the tribal consultation pieces of this bill already. This was adopted in response to COVID-19. It automatically extends the deadline for housing entitlements for 18 months. It would apply to tentative investing, tentative maps, parcel maps, residential development, which is not further defined in the statute. And that kind of opens up the questions, what about an addition to a single family home? It also applies to mixed use projects with at least 2/3 of the square footage dedicated to residential. There are a couple of formulas in the statute, and I've given a citation there to refer to. And on our next slide, this would apply to approvals, permits, and entitlements that are issued by either state or local agencies. Local ministerial approvals and entitlements that are required as a prerequisite to the issuance of building permits. Any local requirement to submit the building permit application within a set period of time. So if you have an entitlement that's approved and then says, submit a building permit within 3 years. Exercising of a vested right related to approvals or permits. And on our next slide, we will talk about what it does not apply to. Even though there's some application to vested rights, it would not apply to development agreements or extended development agreement. It wouldn't apply to a map approval that was or is extended for a minimum of 18 months after March 4th, 2020, which is the kind of beginning of this period where this applies, and preliminary applications per 65941.1 would not apply to applications for development permits for SB 35 multifamily housing projects either. It would not apply also if between March 4th and December 31st, I should say 2021, that's correct, December 2020, the agency does extend the deadline by 18 months. It's less clear if that extension that was granted was for less than 18 months. I think probably the intent here is that any extension that might have been granted should get the 18 months that were contemplated under the statute. And on our next slide, there was some confusion, probably more last year than this year, regarding AB 1561 because it was not adopted as urgency legislation that takes immediate effect. You might remember many of the Subdivision Map Act extension ordinance were urgency legislation and took immediate effect, and you kind of knew your universe of the impacts of that. Here, instead, it was adopted but didn't become effective until January 1, 2021. So language says that the extension should be given to all housing entitlements that are issued prior to and in effect on March 4th, 2020, and which will expire prior to December 31, 2021. Now left open the question of what if an approval expired, say in April of 2020, after that March 4th start date. Was it invalid until January 1, 2021 when it was revived because of the operation of this bill? I think overall the intent suggests that in light of the COVID impacts that this bill was to be interpreted and applied broadly to extend housing development approvals. All right, so now we'll switch to the next bill, which is AB 1851 regarding religious institution housing projects and parking for those projects. So a religious institution affiliated housing development project would be a project that's located on one or more contiguous parcels that are owned entirely by a religious institution. Project has to be near or co-located religious use parking or within 1/10 of a mile of a parcel with that parking. And these projects do qualify for density bonuses. So something to keep in mind as well. For these types of projects, local agencies cannot require replacement of the religious use parking spaces that would be eliminated by the proposed project, or cure any pre-existing parking deficits. So limitations on kind of fixing existing nonconformities. Now on our next slide. Further, the local agency can't deny the project based on parking reductions, provided that the total reduction doesn't exceed 50% of the existing parking spaces. The local agencies don't have to approve a parking ratio that's less than 1 space per residential unit, however. But of course, there's an exception to that, unless the project's within 1/2 mile walking distance of a public transit or within 1 block of a car share vehicle. Probably the car share vehicle language that's been replicated how many ever times still doesn't exactly make sense to me, but that's the language that Sacramento appears to like. Local agencies must also allow the number of religious use parking spaces available after the housing project to count towards the number of spaces that are required for that housing project. And because this relates to the housing shortages, which is a statewide concern, this is also applicable to charter cities. We'll switch now to CEQA. Not a whole lot of CEQA bills last year, but SB 288 passed, and this is a new exemption for sustainable transportation projects. The intent was to spur investment in transit and sustainable transportation, further the state's environmental goals, and create jobs in light of COVID-19. It's valid for 2 years, so just through January 1 of 2023. There are 9 types of projects that qualify for this, and they are statutory exemptions. There's pedestrian and bicycle facility projects, improving transit, bicycle and pedestrian information and wayfinding, transit prioritization projects, signal coordination, etc. City and county projects to reduce parking requirements, designating and converting general purpose lanes to bus-only lanes, instituting or increasing bus rapid transit or light rail, and that would include the transit stations themselves, utility infrastructure, maintenance and repair associated with any of these exempt activities, and any combination of these activities. So that's the scope of the exemptions. The parking reduction one is automatically exempt, so no other criteria, but what would a Sacramento crafted statutory exemption be without a whole list of additional requirements? So for everything other than the parking reductions, there are additional requirements that would have to be met. The project would need to be in an urbanized area, 100,000 population for either this incorporated city or combination of two contiguous cities, or combination with two other incorporated cities, on or within existing public rights of way. So you can't increase or expand into new public rights of way. Can increase automobile capacity. Again, these are transit and other mode emphasis here. Can't involve demolition of affordable housing. And there has to be a commitment to use skilled and trained construction workforce. So project labor agreement, something along those lines. If the project exceeds $100 million, there are some additional criteria as well that would have to be met. It'd have to be within the regional transportation plan or other planning document that underwent a programmatic environmental review within the last 10 years. Construction has to be fully mitigated, or the construction impacts need to be fully mitigated. Lead agency has to consider the project business case. Must also consider racial equity analysis. Must hold 3 noticed public meetings prior to the exemption determination, and at least 2 meetings annually during construction, which are subject to their own specific notice requirements. So there's a lot of public engagement here for an exemption. Also, generally speaking, notices of exemption are optional and not required to be filed at the end of the CEQA process. But for these projects, the notice exemption is required. So you need to file that. So it's not a bad thing, because it also triggers a 35-day challenge period instead of waiting around for a 180-day potential challenge period. So, all right. SB 288 also dealt with the previously adopted bicycle transportation plan exemptions. It was modified. It was extended to January 1, 2030. So that one remains applicable for the foreseeable future. It's for plans for urbanized areas to restripe, or for bicycle parking and storage, intersection signal timing and signage. Again, you have to hold hearings before using the exemption. And again, this notice exemption is required to be filed. And one of the streamlining parts, I guess, of this legislation for bicycle transportation plans is that vehicular traffic, bicycle and pedestrian safety assessments and mitigation, which were previously required, are no longer required. So making that a little more useful tool. All right, next topic, this is AB 2421 regarding cell tower standby generators. This basically requires streamlined processing for permitting emergency standby generators for existing permitted macro cell sites. So these aren't the micro cells, these are the larger ones. And include rooftop, small cell, or indoor-outdoor distributed antenna system sites. This requires ministerial review. It has to meet certain criteria, which are set forth in the law. There's a maximum 60-day review period, or the application will be deemed approved. 10 days to deem the application incomplete, and you need to provide a full list of the outstanding items at that point. You can't require information that would go beyond what is required for any other backup generators. You can't have more strict rules for cell tower backup generators than you have for other types of generators. You can't require the property owner consent as part of the application, which strikes me as very odd. And yet you can require it prior to the installation of the generator itself. Somewhat related, I think, is that California Public Utilities Commission issued a decision 20-07-011. And that decision is a new rule regarding wireless resiliency in high fire threat areas. And plans that there are required to describe how service will be maintained in the event of power outage for emergency communications. So in these areas, you might see a rush of applications to meet a July 2021 requirement to provide 72-hour backup power, again, as a result of that PUC decision. And When we were preparing this, Amber let us know that there was some interest in knowing a little bit about what was going on with the Western Joshua Tree potential listing. So there was a petition that was filed seeking listing of the Western Joshua Tree back in 2019. In September of 2020, the California Fish and Game Commission, having reviewed information, issued a notice of its findings that there was a substantial possibility that the requested listing could occur. And therefore, at that point, the Western Joshua tree is now considered a candidate species, and it needs to be protected like endangered or threatened species in this interim period as they continue going through the potential listing process. The next stage is that the Department of Fish and Game has to issue its report within a year. Although September 24th was the date of the notice of findings, the information that the Fish and Game has posted said they expect to have that completed in October of this year. So stay tuned and see if that becomes formally listed. Not sure whether there's a lot of those in Orange County, but if you've got those around, now that's going to be something to think about when you're going through your CEQA reviews and other things. And with that, I will flip it back over to Diana.
Thank you, Dave. So we're just wrapping up here, and the last thing I wanted to talk about is sort of what is coming down the pike in Sacramento at the moment, what is pending, what is being considered, and how do we as local agency attorneys, planners, and consultants, and planning advocates also think about what we need to be preparing for if some of these bills pass. So a number of these you may have heard about if you were part of the APA webinar last week or 2 weeks ago, you may have heard sort of the details of them. I should say that because they're going through the committee process right now, they are constantly evolving. And so it is a little hard to keep up with the latest and greatest in terms of these pending bills, but there are some themes I would say that are running throughout. There continues to be, of course, in the housing related land use laws world, a pattern of state laws that are superimposing ministerial processes on approvals that traditionally have been discretionary processes at the local level. So again, from what I said before, I think a lot of agencies, if they want to maintain some local control to the extent that eventual housing projects at least look like what they want them to look like, review your design review and zoning standards to see if there are any things that are traditionally done through discretionary permits that you may want to devise objective standards for. Now, I should sort of caution you that under SB 330 last year, of course, if you adopt any new design review standards, they need to be objective now, at least for the next 5 years, and actually likely for longer because SB 8, which is not on this list, but would extend the SB 330 provisions by another few years. So just be mindful of those SB 330 limitations on local actions. But really, I do emphasize that reviewing your zoning and design review standards and trying to put as much into objective standards as possible is a great way to encourage and require applicants to meet those standards and to at least come up with a form and mass of a building that you would be comfortable with at the community level. And of course, I acknowledge how difficult that process may be, and it is not time consuming, but it may be a worthwhile endeavor. So another theme in addition to sort of this ministerial approval process is the idea that the state, in attempting to address the housing shortage and affordable housing crisis in the state, is wanting to encourage the development of housing in areas that either traditionally were lower density or traditionally did not allow housing at all. So you now have a couple of bills pending that would require agencies to approve housing in commercial zones. So just be on the lookout for SB 6 and AB 115. One of the things that I've been trying to parse out and get a read on with these pending bills is well, if housing is not allowed in the commercial zone and all of a sudden we have to allow housing in those areas, what does that mean the standards are? And do your standards in commercial zones address enough of the development standards, or does the language of the statute, when it is finally adopted, if it is finally adopted, refer to a neighboring multifamily jurisdiction or a neighboring residential use that actually has housing standards that make sense in your commercial corridors? That's just something that I think, you know, APA can be mindful of in seeking amendments to these bills, but also that we, in responding at the local level to these bills, if they pass, can start to think about what do we have in place that might apply if this bill were to pass, if these bills were to pass, right? You know, I think this is overriding the separation of uses, at least with respect to residential and commercial, is something that a lot of planners and a lot of local communities are very upset about, because it very much prevents the city from sort of planning for commercial corridors, ensuring economic development and those sorts of things. And so, you know, perhaps being engaged in this legislative process and vocal about what this does to your local planning is an important thing to do during the legislative cycle in ways that perhaps local planners have not been as active in legislative sessions before. But I think there are some big picture changes coming from some of these bills if they are to pass with respect to how local agencies plan. And it's important for us to be aware of these potential changes. The other one that a lot of people have been focused on is Senate Bill 9, which is a sort of a replay of a bill from last year that almost made it and at the 11th hour didn't. And that is the bill that would require agencies to ministerially approve duplexes on single family properties and also approve lot splits on single family properties. There are a lot of limitations on when that lot split can occur, but there are, it would also change quite a bit the fabric of the single family neighborhoods in a lot of jurisdictions. One thing I've been trying to get people to focus on is that we already, because of the ADU laws, no longer have the 1 unit, 1 lot, single family zoning regulations that we may have had at the local level many years ago. At this point already under ADU law, as I mentioned earlier, an applicant can get a junior accessory dwelling unit attached to and within the single family home, as well as either an attached ADU or a detached ADU. So we're already talking about 3 units on a property. And so, you know, some people say, well, that begs the question of why this is even necessary. But it also may also lead to how drastically would SB 9 change what's on the ground at this point. There's a distinction, I think, between the ministerial approval of duplexes and the lot split issue. And so I'm not sure how much of that will move forward. But again, thinking about, well, what would this bill do to our single family neighborhoods? What would it allow? I'm sure your decision makers are going to be asking those questions. So just be aware that this is potentially coming. And we want to be mindful of how we can respond to our decision makers when they ask us questions about what the impact would be. One other big picture theme, I think, is the relationship between planning and very high fire hazard severity zones and wildfire risk reduction. So SB 12 is sort of a very comprehensive bill that addresses the wildfire risk in a number of ways by requiring state agencies to do some research and planning and assessment. And then also that bill at the moment has a provision in it that would require local agencies to amend their housing element and at the same time amend the land use element in ways related to wildfire risk and wildfire risk reduction strategies. One thing I want to note about that bill that I think agencies will be happy about is that it does include a provision that changes the factors that are used for allocating the regional housing needs to various jurisdictions to at least add a factor explicitly addressing the potential wildfire risk. Now, of course, this would not apply in the 6th cycle because we're already moving through that and almost done with that. But if this bill were to pass in its current form for the 7th cycle, that allocation process of RENA numbers would at a minimum take into account the potential for wildfire risk in certain cities when deciding how many units those cities are responsible for zoning for. There are a handful of bills still related to ADUs and density bonus, and I just want to mention them briefly, especially the one that caught my attention this week that I think is like sort of SB 6 and AB 115, a relatively drastic change potentially to how local agencies plan. Senate Bill 778 is an ADU law amendment that on first blush appears relatively minor, but what it allows is the conversion of commercial spaces in mixed use structures. At this point, as I mentioned earlier, the state exempt ADUs include the conversion of non-livable spaces, and the list of non-livable spaces in the statutory language at the moment refers to storage areas, basements, and garages and the like. It does not refer to commercial spaces, and this bill would explicitly add that and essentially allow an applicant, or rather a property owner who already has a mixed use development on the property, to come in and convert vacant commercial space, so long as it's been vacant for 6 months, into ADUs, and the number of ADUs would be equivalent to 25% of the existing units in the building. But there's no requirement that the building still retain any commercial space or maintain its mixed use sort of structure. And so what that really could do is turn buildings that were granted permits originally as a mixed use building, the ability to turn into a fully multifamily building without addressing the potential change to the walkability of the area or the climate change goals that may be the basis for the mixed use requirements in the first place, or the fact that in that zone, a fully multifamily building might have different development standards than a mixed use building. So that bill would make some pretty drastic changes through a minor change to ADU law, and I bring it to your attention because it's going through the committee process now. And so if you have mixed use areas and you want to be thinking about how this bill would affect it, it may be something to bring to your decision makers' attention as to whether they want to weigh in on the legislative process. On the density bonus side of things, there are a handful of bills. I put 4 of them here, but there's actually maybe 2 or 3 more as well. Some of them are minor. So AB 571 simply says that for the affordable units in the development, you cannot impose fees on those units. So you're only going to be charging fees for that development based on the number of market rate units that are in the development. SB 728 changes the process by which a density bonus project that is a for sale project sort of deals with their affordable units, essentially saying that those affordable units could be sold to a nonprofit so that they would deal with the restrictions on resale and that sort of a thing. SB 290 would specifically address low-income student housing projects and has a few other minor changes in it. And then SB 55 is one that just came to my attention, which is interesting because what it does is sort of again tie development and wildfire risk together. But in this instance, it actually grants projects that are density bonus projects that are not in a wildfire area a potentially higher height limit and higher density bonus above what they might get through the incentive concession process and the normal density bonus process, so long as the project is not in a high fire risk area. So that's an interesting one to keep an eye on. I'm not sure how that'll move. And again, there are a couple more. But my takeaways from all of this is there could be some drastic changes coming. And On the one hand, as planners, our options at this point are to either get involved in the legislative process or prepare for what's coming and simply accept it. But at the same time, we definitely need to be educating our decision makers about any changes to what development is going to look like in the community, the changes to their discretionary authority. They're in a lot of instances used to having discretionary authority over some of these things, or used to being able to say, we don't want housing in this particular commercial area or in commercial areas at all. And a lot of these bills would take away that local planning authority, or at least amend that local planning authority. So I think, it'll be really interesting to see what happens this legislative session. And in terms of responding, again, I think preparing our decision makers for some of this, making them aware of it so that they can get involved if they want to in the legislative process, and then preparing to, at the local level, address our own objectives and processes and say, okay, if the state continues to do this, what can we do to put into place streamlined processes that allow for housing on the basis of a set of objective standards that we have put in place, that construct developments that we're okay with, at least in mass and form, and how do we do that quickly enough? So that's sort of my wrap up on what's coming and how to prepare. And I imagine there'll be a few questions, so I'll turn it over to Amber and Patrick at this point to start that process.
Perfect. Thank you so much, Diana and David. And I just want to reiterate what Diana said, and thank you for bringing that to our attention on how much legislation is really changing right now in our roles as planners. I think we as planners know better than anyone that if you don't enter the process early on, it's really hard to make change once, like a project is approved. It's hard to change that project once it's approved. It's the same with the legislation. You really have to get in on the ground floor while it's being written. So not that our plates aren't full already, but we really do have to just be aware of that legislation. So thank you so much for that. And with that, I'm going to turn it over to my legislative co-chair, Patrick Cruz from DUDEC. And if you have a question, again, go ahead and write it in our question and answers. And Patrick, do we have any questions?
We do, yeah, we have a few. I think the first couple are aimed at Diana. This one, I think, is about AB 2345. And it's, is there really no size limit for an ADU for multifamily residences?
So the answer to that is that subdivision E of section 65852.2, the ADU law, does not explicitly limit the size of those ADUs. Elsewhere in the ADU law, they have this default of 1,200 square feet in subsection A. And then there is the authority under local law to limit it to 850 square feet for a one bedroom and 1,000 square feet for a two bedroom or more. But for those multifamily ADUs under subdivision E, for converting space or building two new detached ADUs, there is not explicitly a limit. Now, I think that it's a reasonable interpretation to say 1,200 square feet, the default under subdivision A, is an appropriate limit. And I would not be surprised if we get some cleanup legislation to clarify that, because I actually think the intent was to have that 800 square foot limit for the new detached single family units be the same for the new detached multifamily units. But again, it's not explicit at the moment in state law.
Great, thanks. So then moving on to the Housing Accountability Act, if it says that potential rezone sites must allow applicants to build housing without rezoning completed, what do agencies have to rezone?
Yeah, so it's a fair question. State law does require, even for charter cities now, that your general plan and your zoning code be internally consistent and vertically consistent as well. So your general plan has to be internally consistent, and then your general plan and your zoning code are supposed to be consistent as well. That specific provision of the HAA talks about inconsistencies and was specifically intended to address this situation where you have a housing program that says you're going to do this, but then the agency doesn't. I think one reason for doing that is you can A, make it clearer for the folks who come in exactly what is required, and B, establish more in terms of the procedures, what the application process looks like, who the reviewing entity is, all of that in your zoning code that you would not probably include in terms of the details in your general plan. So I think there's still some benefit to updating your zoning code to be consistent with your general plan. And then there's always the question, is your general plan actually inconsistent with your zoning code? So I recommend working with your council to update your zoning code, but I hear the point, and I think I understand the frustration that at a certain level, for years and years, we've depended on this framework that your general plan is sort of a big picture constitutional document that sets out the umbrella framework at a high level, at a 40,000 foot level, and then your zoning code comes in with the details. The bills in the last few years have sort of flipped that on its head, and now I think as you're preparing your general plan, especially your housing element, you do want to include a lot more details than you may have previously, for the reason that if it's inconsistent, the general plan might prevail. So that would be my sort of recommendation.
All right, and then as a follow-up question to that, would rezoning to be consistent with the general plan no longer be subject to CEQA since the Housing Accountability Act makes it no longer discretionary?
That is a good question. I need to think about that one. I'm not sure I have an answer off the cuff. There is a provision of state law that talks about housing element implementation programs and when they are exempt from CEQA. And so there may be, if you've already done an EIR for your housing element, an opportunity to just fall within that exemption. I believe there's also a pending bill that would change that. I think it's AB 1486, maybe. Yeah, AB 1486 that talks about the CEQA and housing provisions. But it's not explicit, I guess I should say. I think there are a number of ways where you would argue that, though.
Yeah, that's a good one. Moving on to SB 9, doesn't SB 9 limit demolition of existing structures to 25% of the structure, so that the change on the ground wouldn't necessarily be that drastic?
That's one of the arguments I've heard in favor of SB 9 for sure, and I think SB 9 is a very controversial bill, including within the APA and planning community. I think people have very strong opinions on this either way. I am not familiar enough with the details of SB 9 to specifically speak to that. I think the important question is, are we talking about the multifamily duplex development the duplex development, or are we at ministerial level, or are we talking about the lot split? And so I think it's true. It is a question of how much will that bill affect development on the ground, and I think it's still unclear and is going to depend a lot on the final details of the bill, how easy it makes it for these processes to occur, and how profitable and financially enticing it is for folks to come in, especially in areas where land value is lower, to buy up properties, split them, and sell them at a profit relatively quickly. So I think it's really going to be, it might have quite a regional effect, but that's just my supposition. And like I said, I think SB 9 is going to go through some significant changes, would be my guess, at least in the details as it moves through the system.
All right, and then we've got a couple of questions about ADUs, of course. Can a JADU be built in an attached garage, or is solely limited to the inside habitable space of an existing residence?
That is the eternal question. I think the definition of JADU talks about within the single family residence, and 65852.22, which is the JADU provision, talks about within the walls of the single family residence. So I have interpreted that to mean that they have to be within the home, not within an attached garage. That said, I believe HCD takes a different interpretation, and a number of housing advocacy groups take a different interpretation. The reason for my interpretation is that you are already allowed to convert a garage, regardless of whether it's detached or attached, into an ADU. And the distinction there is just that it has to have its own bathroom, really, in practice. And so I just think it's important for people to keep in mind what these interpretations mean in practice and sort of where do we go from there. So, you know, my hope is we'll get some legislative cleanup on that particular point as well, because I've had this come up in a number of instances. But yeah, but I think that's also a point that's not entirely clear yet.
Right. And then does the exempted attached ADU have to be within the existing footprint of or existing building envelope? What happens if the proposed attached ADU is partially or fully in addition?
So there is a provision under the conversion that says you can build an additional 150 square feet onto an accessory structure if you're converting that accessory structure into an ADU. For the conversion provision, it does not have that same language in terms of the conversion of space within the single family home. So my interpretation of that is that if you're converting space within the single family home, there cannot be any expansion of the space of the single family home for you to fall within that building permit only state exempt category. That doesn't mean you couldn't arguably do it through subdivision A and the local ordinance standards, but I think for the purpose of those specific conversion provisions, that does not explicitly allow for that scenario.
All right, great. Well, I think that wraps up our question and answer portion as we've gone through all of the questions. With that, I'll pass it back to you, Amber.
Great. Thank you so much, Patrick. I just want to say thank you so much again to our panelists. This information is invaluable, and you always do such a great job at making it digestible for us at the local levels. So thank you very, very much for that. And for anyone who needs to reference this, it will be posted on the website at a later date once we get it all cleaned up and updated. So that way you can reference it over and over again at your leisure. And hopefully we can do this in person next time. That might be a nice change of pace as well. So thank you so much, everybody, for joining us, and we look forward to seeing you next time.
Thank you, Amber, for coordinating, and Patrick.
Yes, thanks.
Yeah.
Thank you, guys. Yep.